The last morning, the alarm doesn't wake him. He never slept. At 6 a.m. on September 21st, 2011, Troy Davis opened his eyes in a holding cell at Georgia Diagnostic and Classification Prison. He already knew what day it was. He had known for weeks. But knowing and feeling it, those are two entirely different things. He didn't eat breakfast. Most of them don't. Across the country, in a different decade, a different man, John Wayne Gacy, requested a final meal of fried chicken, shrimp, French fries, and a pound of strawberries. He ate every bite. Then he waited. His execution at Stateville Correctional Center in Illinois on May 10th, 1994, was delayed for over an hour because a vein couldn't be found. He lay strapped to a gurney, staring at a ceiling, for 63 minutes longer than scheduled. One man couldn't eat. Another ate everything he could. Both were dead before midnight. This is what the last 24 hours on death row actually looks like. Not the Hollywood version, not the sanitized version, the real one. Documented by prison records, journalist accounts, clemency hearings, execution logs, and the testimonies of the people who were in that room. What happens inside those final hours reveals something about the system, about human psychology under the most extreme pressure imaginable, and about the machinery of state-sanctioned execution that most people never see. By the end of this video, you will understand exactly what unfolds, hour by hour, in the last day of a condemned person's life. And some of what you're about to learn will disturb you. Not because it's violent, but because of how ordinary parts of it are. Before we dive in, drop a comment and let us know where you're watching from. We'd love to hear from you. If you enjoy true crime stories like this, be sure to like the video, subscribe, turn on the notification bell, and share it with someone who'd love it too. The last 24 hours on death row is not a single dramatic moment. It is a process, a bureaucratic, carefully scheduled, legally governed process with forms, checklists, meal orders, phone call logs, and visitation schedules, all building toward a single predetermined outcome. And it begins not at midnight, not at dawn. It begins the moment the execution date becomes real. If you enjoy real, gripping prison documentaries and true stories, don't forget to like this video, leave a comment, and share it with your friends and family. Hit that subscribe button and turn on notifications so you never miss more shocking and exclusive content. The transfer. What happens when they move you to the death house? Most people assume death row is where you die. It isn't. In the majority of American states that carry out executions, condemned inmates spend their final years, sometimes decades, in a designated death row unit. But in the final hours, they are moved, transferred to a separate facility, a separate building, or a separate wing that corrections officers and inmates alike call by a name that leaves nothing to the imagination. The death house. And that transfer, that moment when they come for you, is when it becomes real in a way that no court date, no appeal ruling, no legal document ever made it feel before. Round pushpin, the mechanics of the move. According to documentation from the Texas Department of Criminal Justice, which has carried out more executions than any other state in the modern era, condemned inmates are typically transported to the Huntsville unit, known simply as the Walls, roughly 24 hours before their scheduled execution time. The Walls is one of the oldest prison facilities in Texas. Its brick exterior sits in the middle of downtown Huntsville. Locals drive past it every day. People eat lunch within 2 blocks of it on execution days. Inside, there's a specific cell, the Death Watch cell, that has held more condemned men than perhaps any other single room in American corrections history. When an inmate arrives, they are processed again, as if they are new, as if the system needs to formally receive them one final time before releasing them in the only way it ultimately intends to. Their existing prison-issued property is inventoried. Their clothing is exchanged. They are assigned to a cell that is closer to the execution chamber than any place they have ever been housed before, sometimes separated from the chamber itself by nothing more than a corridor and a door. The cell is small, approximately 45 square feet in most documented facilities. There is a bunk, a toilet, a sink. In some states, there is a small television. In others, there is not. Former Texas Department of Criminal Justice Warden Jim Willett, who oversaw 89 executions during his tenure and later spoke extensively with journalists and researchers about the process, described the death watch cell in interviews as deliberately plain. Not as punishment, but as policy. The less stimulation, the less acute the psychological distress, at least in theory. The theory doesn't always hold. Round pushpin, what documented accounts reveal about the transfer. David Leisure, executed in Missouri in 1999, reportedly became visibly disoriented when transferred to the death house. According to prison staff accounts compiled by journalists covering Missouri's execution protocols at the time, Leisure appeared to dissociate, responding slowly, moving mechanically, repeating questions he had just been answered. This is not unusual. Researchers studying death row psychology, including work published through organizations that monitor capital punishment practices, have documented a phenomenon sometimes called death row syndrome, a deterioration of mental functioning that accelerates sharply in the final days as execution becomes imminent. The transfer itself, the physical act of being moved, can function as a psychological trigger that collapses whatever remaining psychological defenses an inmate has built up over years of waiting. Some inmates have been on death row for over 2 decades before their execution date arrives. The transfer ends a chapter of existence, however bleak, that had become, in a disturbing way, familiar. Familiar is safer than what comes next. Round pushpin the guards who walk with them. The transfer is not done alone. In most documented state protocols, the condemned inmate is accompanied by a designated team, sometimes called a death watch team or escort team, that has specific responsibilities during the final 24-hour period. These officers are not randomly assigned. According to research and reporting on the Texas execution process, officers who serve on execution teams typically volunteer for the role and receive specific training. They are chosen, in part, for their ability to maintain composure and to project calm under conditions that most human beings will never experience. Former corrections officer Brian Price, who served on Texas execution teams and later wrote about the experience, described the relationship that forms between the condemned and the escort team in the final hours as something he struggled to characterize. It was not friendship. It was not indifference. It occupied some space between professional obligation and something closer to witness. His job was to be present, to make sure the process moved correctly, to make sure the person in front of him was treated with a baseline of dignity, not because the law required it in any document he was shown, but because something in his training and in his own moral processing required it of him. Price later left corrections work. He was not the only execution team member documented to have done so. Round pushpin, the 24-hour watch begins. Once the inmate is settled in the death watch cell, the formal 24-hour observation period begins. This is documented and required. In Texas, the condemned is under continuous observation from the moment they arrive at the Huntsville unit. Officers are stationed to maintain line-of-sight contact at all times. This is not for punitive reasons. The official rationale, consistent across multiple state protocols, is prevention, specifically prevention of suicide or self-harm that would interfere with the execution. The condemned cannot take their own life. The state has scheduled that for them. This detail, that the system prevents self-harm in order to preserve its own authority to cause death, is one that has been noted by legal scholars, ethicists, and journalists covering capital punishment for decades. It has never been resolved. It sits in the documentation as a contradiction that no protocol manual addresses. Warden Willett, in his interviews, acknowledged the psychological weight of this particular reality without framing it as policy criticism. It was simply, in his words, part of what the job required him to hold. Round pushpin, the first phone calls. Within the first hours of arrival at the death house, the condemned is permitted to make phone calls. Not unlimited calls. Not calls to anyone. The calls are monitored, logged, and constrained by facility rules that vary by state, but follow a general pattern. Family members, attorneys, and in some cases spiritual advisors. For many condemned inmates, this is the first time in years, sometimes the first time in the entire period of their incarceration, that they call family members they have not spoken to in months. Troy Davis, in the hours before his execution on September 21st, 2011, made calls to family members and supporters. His case had drawn international attention, with over 1 million people signing petitions for clemency and figures ranging from Pope Benedict XVI to former U.S. President Jimmy Carter calling for a stay of execution. None of it had worked. His final appeals had been exhausted the same day. When he picked up the phone in that holding cell, the person on the other end knew, and he knew, that the number of times they would ever speak again could be counted on one hand. Documented accounts from people who received final calls from condemned inmates described the conversations as disorienting in their ordinariness. People talking about family memories, about love, about regret, about things that needed to be said that had never been said. And then the call ends, and the phone is there, and it is allowed one more call, and then one more, and then the calls run out. Round pushpin what the attorneys are doing. While the condemned is in the death watch cell, their legal team is typically in motion. Even in the final 24 hours, attorneys in capital cases have been documented filing last-minute motions, pursuing emergency stays, contacting governors' offices, and coordinating with advocacy organizations. In the Troy Davis case, his attorneys filed multiple last-minute appeals to the U.S. Supreme Court on the day of his scheduled execution. The court considered the request. The execution was delayed for several hours while the court reviewed and then denied the appeal. During those hours of delay, Davis remained in the holding area, waiting, not knowing if the delay meant something had changed or if it was simply the machinery of law completing its final rotations before arriving at its predetermined conclusion. It was the latter. He was executed at 11:08 p.m. Round pushpin the psychological architecture of the wait. What researchers and documented accounts consistently reveal about this first phase of the final 24 hours is that the wait itself functions as a distinct psychological event. Dr. Craig Haney, a psychologist at UC Santa Cruz who has spent decades studying the psychological effects of incarceration and death row confinement, has documented through his research and testimony in capital cases that the anticipatory suffering, the suffering of knowing, is qualitatively different from any other form of psychological distress the condemned has previously experienced. The body responds to the knowledge of scheduled death. Sleep becomes nearly impossible for most. Appetite collapses. Time distorts. Some inmates describe minutes feeling like hours. Others describe hours dissolving without awareness. Some become preternaturally calm. Documentation from correction staff in multiple states describes condemned inmates who appear almost serene in the death watch cell, cleaning their small space, speaking quietly and rationally, expressing concern for the officers around them. Others deteriorate visibly. Documented cases include inmates who required medical assessment during the final hours due to acute psychological distress, not as a delay tactic, but as genuine crisis response. Both responses, the calm and the collapse, are documented in the literature on capital punishment psychology as rational responses to an irrational situation. Because what the condemned person is living through in that cell has no parallel in human experience. They know exactly when they will die. They know the room it will happen in. They know the faces of some of the people who will be there. And they must sit with that knowledge in a 45-square-foot cell under fluorescent light with someone watching them from outside the bars until the time comes. Round pushpin the paperwork they sign. Before the day is done, there is paperwork. This detail rarely appears in media coverage of executions, but it is documented across state protocols. The condemned is asked to make decisions about their body after death, burial arrangements, donation, handling of remains, about their personal property, the small accumulation of items permitted on death row, about their final statement, whether they wish to make one, and if so, whether they want it written in advance or spoken in the chamber. Some inmates have lawyers or family to help navigate these decisions. Others do not. The property inventory, the formal list of what a person owned in their final chapter of life, is one of the more quietly devastating documents generated by the execution process. Documented property lists from death row inmates have included family photographs, legal documents, paperback books with cracked spines, letters, drawing materials, a radio, a pair of worn sneakers. These items are cataloged, receipted, distributed, or disposed of according to the inmate's expressed wishes or, in the absence of those, according to facility policy. The system is thorough. It accounts for everything. It leaves nothing uncatalogued. By the time the first 6 hours of the final 24 have elapsed, the condemned inmate has been moved, processed, observed, permitted phone calls, surrounded by attorneys working against the clock, assessed psychologically, and asked to sign paperwork about their own death and the disposition of their earthly belongings. And the clock has not yet reached noon. There are still 18 hours to go, and at some point in those 18 hours, they will be asked what they want to eat. Open Book Chapter 2, The Last Meal, the Ritual, the Reality, and What It Reveals. In 2011, the state of Texas abolished the last meal, not because of budget concerns, not because of a policy review, because of one man's order. Lawrence Russell Brewer, convicted of the 1998 dragging death of James Byrd Jr., one of the most racially motivated murders in modern American history, requested a final meal that included 2 chicken fried steaks, a triple meat bacon cheeseburger, a cheese omelet, a bowl of fried okra, 3 fajitas, a meat lover's pizza, a pint of Bluebell ice cream, and a slab of peanut butter fudge. He didn't eat a bite of it. When the tray was returned untouched, Texas State Senator John Whitmire, a Democrat who had served longer in the Texas legislature than almost anyone alive, was so outraged that he fired off a letter to the Texas Department of Criminal Justice demanding the practice be ended immediately. Within 24 hours it was. Brewer was executed the same evening he refused his meal. September 21, 2011. The same night Troy Davis was executed in Georgia, on opposite ends of the country, in 2 cases that could not have been more different in terms of public perception of guilt. But that moment, a tray of uneaten food, a senator's fury, and the end of a practice that had existed in American corrections for over a century, reveals something important about what the last meal actually is. It was never really about the food. Round Pushpin, the history of the practice. The tradition of offering a final meal to the condemned predates the American prison system entirely. Documented historical records trace the practice to ancient Rome, where condemned prisoners were offered a meal before execution as both a practical measure. An empty stomach was believed to cause slower death, and a ritual acknowledgement of shared humanity between the state and the condemned. In medieval Europe, the practice evolved into something more socially elaborate. The final meal was sometimes a public event, shared with officials or clergy, functioning as a form of communal absolution, a last moment of ordinary human participation before extraordinary human judgment was carried out. In American corrections, the modern last meal protocol developed through the 20th century alongside the formalization of execution procedures. By the time lethal injection became the dominant method of execution in the 1980s and 1990s, the last meal had been codified into official policy in most death penalty states, governed by rules about cost limits, available kitchen resources, timing relative to execution, and nutritional considerations related to the execution method itself. That last point matters more than most people realize. Round Pushpin, the medical dimension. The last meal is not simply a courtesy. In the context of lethal injection, the execution method used in the vast majority of American executions since its adoption, what the condemned eats in the final hours has documented medical relevance. The standard 3-drug lethal injection protocol historically used in the United States involves a sedative, a paralytic agent, and potassium chloride to stop the heart. The administration of these drugs through intravenous lines requires functional venous access, and the body's hydration and nutritional state affects vein accessibility. This is documented in the medical and legal literature surrounding lethal injection challenges. Court cases challenging execution procedures have included testimony from medical experts about the physiological conditions of the condemned at the time of execution, including their last known nutritional intake. Beyond the clinical dimension, prison medical staff in most documented state protocols conduct a brief health assessment of the condemned during the final 24 hours, not for treatment purposes, but but to establish a baseline and to ensure that no acute medical condition would complicate the execution procedure. The condemned is assessed for medical fitness to be executed. That sentence exists in American Corrections policy documentation. Round pushpin, what they actually order. The documented record of last meal requests in the United States is one of the more psychologically revealing archives in the history of American corrections. The Death Penalty Information Center and various journalistic and academic investigations have compiled records of last meal requests over decades. The patterns that emerge are not what most people expect. The most common requests are not elaborate or expensive. They are comfort food, simple food, food associated with childhood, with home, with moments that predate the crimes, the trials, the decades of incarceration. Hamburgers appear more than almost any other item. Fried chicken is a close second. Ice cream, specifically flavors associated with childhood, like vanilla or strawberry, appears with striking regularity. Henry Lee McCullum, exonerated from North Carolina's death row in 2014 after spending 30 years incarcerated for a crime DNA evidence proved he did not commit, later described in interviews how he had thought about what his last meal would be during the years he believed his execution was inevitable. His answer was not dramatic. It was simple food he associated with his childhood in South Carolina. He never had to order it, but the fact that he had thought about it, had mentally rehearsed the ritual, reveals how deeply the last meal functions as a psychological landmark in the death row experience, regardless of whether it is ever consumed. Round pushpin the requests that became famous. Some last meal requests entered the public record because they were unusual, others because they were heartbreaking, others because they said something about the person that their trial records never captured. Ricky Ray Rector, executed in Arkansas in January 1992, an execution that drew national attention because then Governor Bill Clinton left the presidential campaign trail to return to Arkansas and deny clemency, had been rendered severely mentally impaired by a self-inflicted gunshot wound to his head following his crime. His mental capacity at the time of his execution became the subject of intense legal and ethical debate. His last meal included a slice of pecan pie, which he set aside, telling staff he was saving it for later. He did not understand that there would be no later. The detail entered the documented public record through journalist accounts of his final hours and became one of the most cited examples in academic literature on the ethics of executing the mentally impaired. John Wayne Gacy's elaborate final meal, documented in detail by corrections staff accounts and journalistic coverage, was interpreted by psychologists and criminologists as consistent with his behavioral profile throughout his life. Maintaining control, performing normalcy, refusing to signal fear or weakness even in the face of death. He reportedly chatted with correction staff during his meal, remained composed, asked about their families. He was dead by 12:58 a.m. Round pushpin the requests that were refused. Not every last meal request is granted. State protocols governing last meal requests vary significantly. Texas, before abolishing the practice, operated under a policy that limited last meals to items available through the prison commissary or standard kitchen, which excluded most restaurant food and imposed informal cost limits. Other states operated with more flexibility, with some documented cases of wardens arranging for specific restaurant orders to be placed for condemned inmates, paid for by the state by staff collections or by family members. But some requests, regardless of policy, fell outside what could be provided. Requests for alcohol have been universally declined in documented American execution protocols. Requests for illegal substances, documented in at least several cases by correction staff who recounted the requests years later in interviews, were declined without elaboration. One documented case involved an inmate who requested a specific meal his mother used to make. The prison could not replicate it. He received the closest approximation the kitchen could manage. He reportedly told the officer who delivered it that it wasn't right, that it wasn't what he meant. He ate anyway. Round pushpin when they don't eat. A significant number of condemned inmates declined the last meal entirely. Timothy McVeigh, executed on June 11, 2001 at the Federal Correctional Complex in Terre Haute, Indiana for the 1995 Oklahoma City bombing that killed 168 people. Chose 2 pints of mint chocolate chip ice cream as his final meal. He ate them, but the documented accounts of his final hours describe a man who had, by most observable indicators, psychologically concluded his life some time before the execution itself. He had ceased appeals. He had expressed a desire to proceed without delay. He had made his peace, or something that functioned like peace, before the final day arrived. In contrast, some inmates refuse food entirely as a final act of agency. In a process over which they have no control, the date, the method, the witnesses, the outcome, the decision not to eat is one of the few choices that remains entirely theirs. Documented correction staff accounts from multiple states describe the refusal of the last meal not as dramatic protest, but as quiet assertion. An inmate who will not choose what to order, or who orders something and leaves it untouched, is communicating something that no one in the system is officially required to acknowledge. But the officers in that corridor acknowledge it. The chaplains acknowledge it. The wardens, years later in interviews, acknowledge it. Round pushpin the hour after the meal. The period following the last meal, roughly 2 to 4 hours before the scheduled execution time in most documented state protocols, is when the pace of the final day shifts. The calls become fewer. The paperwork is completed. The attorneys have either secured a stay or they haven't. What remains is the waiting. And in that waiting, something documented across dozens of accounts from corrections staff, spiritual advisors, and family members who were present begins to take shape. The condemned starts, in many documented cases, to say goodbye. Not dramatically, not in speeches, but in the small, quiet language of people who understand that time is now being measured in increments that can be counted. Former Warden Gene Woodford, who oversaw 4 executions at San Quentin State Prison in California before becoming a prominent death penalty opponent, described this period in multiple interviews as the one that stayed with her longest. Not the execution chamber, not the moment of death, the hour before, when the person in front of her was still entirely alive, still speaking, still present, and both of them knew, with complete certainty, that this was ending. She described it as the most human thing she had ever witnessed in her career in corrections, and the most terrible. Round pushpin what the meal actually means. Academics, ethicists, and corrections professionals have offered varying interpretations of the last meal tradition over the decades. Some frame it as the state's acknowledgement of shared humanity, a ritual recognition that the person being executed is, despite everything, a human being with preferences, memories, and a relationship to ordinary physical pleasure. Others frame it as theater, a performance of mercy that costs the state almost nothing and provides a veneer of civility over what is, at its core, a calculated act of killing. Still others, including some of the condemned themselves in documented final statements, have rejected the framing entirely, have stated that no meal, no ritual, no courtesy extended in the final hours changes what is happening or what has been decided. What is documented across decades of records and testimony is this: the last meal is the final moment in the execution process where the condemned is asked what they want. After that, what happens to them is no longer subject to their preferences. The question will not be asked again. Outside the death house, the sun is going down. The execution is scheduled for tonight. The meal is finished or it isn't. The attorneys have stopped calling or they haven't stopped yet. And inside the death watch cell, something is beginning to happen that no protocol manual covers and no training prepares anyone for. The condemned is beginning to say the things that cannot be left unsaid. The spiritual advisor is at the door. The chaplain and the condemned faith, doubt, and the last conversation. He knocked on the cell door at 7 p.m. He always did. Carol Pickett served as the death house chaplain at the Huntsville unit in Texas for 15 years. During that time, he was present for 95 executions. He stood in more death watch cells at more final hours, with more condemned men than perhaps any other individual in the documented history of American capital punishment. He was not there to convert anyone. He was not there to offer absolution on behalf of an institution. He was there because, in his own words, documented across interviews and in his memoir Within These Walls, someone needed to be present who had no other role in what was about to happen. No protocol to enforce. No legal obligation to fulfill. No official function in the machinery of the execution itself. He was there to be human, in a place and at a moment when everything else had become procedural. And what happened in those cells, in those final hours of conversation between a chaplain and a condemned man, constitutes one of the most documented and least discussed dimensions of the American execution process. Round pushpin the role that isn't in the manual. Every state that carries out executions has some provision for spiritual care in the final hours. The specifics vary. Some states employ full-time chaplains assigned to the execution unit. Others rely on contracted clergy or volunteers. Some allow the condemned to request a spiritual advisor of their own choosing, a pastor, imam, rabbi, or other religious figure from outside the prison system, to be present in the final hours and, in some states, in the execution chamber itself. The legal framework governing this aspect of execution protocol has been tested in court. In 2019, Patrick Murphy, a Buddhist practitioner on Texas death row, requested that a Buddhist spiritual advisor be permitted in the execution chamber with him, as Christian chaplains had historically been permitted. Texas denied the request. The U.S. Supreme Court halted his execution while the matter was considered, and the case ultimately led to a significant policy shift. Texas announced it would no longer allow any chaplain of any faith inside the execution chamber, rather than accommodate the equal access requirement the court's reasoning implied. The decision was widely criticized by death penalty opponents, prison reform advocates, and clergy of multiple faiths who argued that removing spiritual presence from the chamber entirely was a more cruel outcome than the one the policy was intended to avoid. It remains policy in Texas today. Round pushpin, what Chaplain Pickett documented. Carol Pickett's 15 years of documented service at Huntsville produced a body of first-hand testimony that is, by any measure, one of the most comprehensive human records of the final hours before execution available in the public domain. His accounts, compiled across his memoir, interviews, and the 2000 documentary At the Death House Door, describe patterns that repeated across nearly 100 individual cases, but also the ways in which each person remained irreducibly individual in how they faced what was coming. Some men, Pickett documented, wanted to talk about their crimes. Not to confess in a formal religious sense, but to process, to speak the thing aloud to another human being in a space where the legal consequences of speaking had ceased to matter. Some wanted to talk about their families, about children they hadn't seen in years, about parents who were dead or who had stopped visiting, about relationships that had collapsed under the weight of what they had done or been accused of doing. Some didn't want to talk about any of it. Some wanted to play cards. Pickett documented playing cards with condemned men in the death watch cell on multiple occasions. Not as distraction therapy, not as programmed activity, simply because a man who was going to die in 4 hours wanted to play cards, and Pickett understood that meeting a person where they are not where you think they should be was the only form of pastoral care that meant anything in that room. Round pushpin faith on death row, what the data shows. The relationship between condemned inmates and religious faith is more complex than popular representation suggests. Research into the religious practices and beliefs of death row populations, including studies conducted through prison chaplaincy programs and academic work on religious conversion in carceral settings, documents significant diversity. Some condemned inmates arrive at their execution date with deeply held religious convictions that have sustained them through years of incarceration. Others adopt or deepen religious practice on death row as a response to the psychological conditions of that environment. Still others maintain no religious affiliation throughout. What is documented consistently across chaplaincy records and correction staff accounts is that the final hours tend to produce theological questions regardless of prior religious affiliation. Not always questions about the existence of God or the afterlife, though those appear in the documented record frequently. More often, questions about meaning, about whether a life that ended this way could be said to have meant something, about whether the harm caused, and most condemned inmates, even those maintaining legal innocence of the specific crime for which they were sentenced, carried documented histories of harm, could exist alongside the capacity for redemption. These are not questions the chaplain is expected to answer. In every documented account of effective prison chaplaincy in execution contexts, the role is not to provide theological resolution, but to remain present with the unresolved, to not flinch from the weight of the question, to not offer easy comfort that the situation does not support. It is, by any measure, one of the most psychologically demanding forms of pastoral work that exists. Round pushpin the cases where faith was central. Some executions have entered the documented record specifically because of the role faith played in the condemned's final hours. Carla Faye Tucker, executed in Texas on February 3, 1998, becoming the first woman executed in that state since the Civil War, had undergone a well-documented religious conversion during her years on death row following her conviction for a 1983 pickaxe murder. Her case drew international attention not only because of her gender, but because of the credibility in the assessment of prison staff, clergy, and journalists who knew her of her transformation. Carol Pickett was with her in her final hours. His documented accounts describe a woman who was, by all observable evidence, at peace, not in a performed or theatrical sense, but in a way that he found both deeply moving and deeply challenging to reconcile with the fact of what was about to happen. She prayed. She spoke about her faith without defensiveness or performance. She expressed love for the people in her life and grief for the harm she had caused. She was executed at 6:45 p.m. Pickett documented that her execution affected him differently from others, not because of her gender or her fame or the public controversy surrounding it, because of what he witnessed in that cell in the hours before. He retired from his chaplaincy role not long after. Round pushpin when the condemned rejects spiritual care. Not every condemned inmate wants a chaplain. Timothy McVeigh, whose execution in 2001 was among the most publicly documented in American history, with closed-circuit viewing arranged for survivors and victims' family members, explicitly declined religious counsel in his final hours. McVeigh had been raised Catholic, but described himself in documented interviews as an agnostic. He chose as his final statement to read, in written form, the Victorian poem Invictus by William Ernest Henley, a poem whose final lines assert unconquered self-determination in the face of death. His choice was interpreted differently by different observers. Some saw defiance. Some saw ego. Some saw a man attempting to maintain, until the very end, the narrative of personal control that had defined his stated motivations. What the documented record shows is that his rejection of spiritual care was consistent with his documented psychological profile throughout his incarceration, a man who had decided what the story of his life meant and was not going to revise that meaning in its final hours. The chaplain was available. McVeigh did not want him. That, too, is part of the documented record of last hours. Round pushpin the conversation that cannot be prepared for. Carol Pickett documented one aspect of his 15 years at Huntsville that he described as the most consistent and least expected pattern across nearly 100 executions. In the final 2 hours, almost without exception, the conversation shifted. Not dramatically, not with a declared transition, but the quality of what was being said changed. The practical, the family calls, the legal updates, the meal, the property, had receded. What remained was something Pickett described as the most stripped-down form of human communication he had ever witnessed. Men who had maintained emotional distance for hours, sometimes for years, would begin to speak about what they loved. Simple things, specific things, a particular stretch of road in a place they grew up, the smell of something, the memory of a specific afternoon that seemed, in retrospect, to contain everything that life had been or could have been. Pickett documented this pattern not as spiritual breakthrough or deathbed conversion, but as something he came to understand as the natural consequence of the one thing the final hours do that nothing else in life does. They make the irreversibility of time impossible to avoid. Most human beings spend most of their lives with the ability to defer, to tell themselves that there is still time to fix what is broken, to say what hasn't been said, to be what they haven't yet become. In the death watch cell, that capacity for deferral ends. What is unsaid must be said now, or will remain unsaid permanently. What is unfelt must be felt now, or will not be felt at all. Pickett described sitting with men who wept not from fear, but from grief. Grief for specific people, specific moments, specific versions of their lives that had not happened and now could not happen. He described it not as a spiritual phenomenon, but as a human one. The most human thing he had ever seen in the least human setting imaginable. Round Pushpin, the spiritual advisor from outside. In states that permit it, condemned inmates may request that a spiritual advisor from outside the prison system accompany them in the final hours. This figure, sometimes a pastor from a church the inmate or their family belongs to, sometimes an imam, sometimes a spiritual director from an outside organization that ministers to death row populations, occupies a different role from the institutional chaplain. They arrive carrying a relationship with the condemned that predates the final day. They have visited before. They know the person's history, their family, their stated beliefs or doubts. They are not institutional. They are not procedural. Their presence has been documented in accounts from families and from the spiritual advisors themselves as one of the few elements of the final hours that functions as a genuine human constant. A familiar face in a setting where everything else is institutional and strange. Sister Helen Prejean, whose work with condemned inmates on Louisiana's death row is documented in her memoir Dead Man Walking, and whose advocacy against capital punishment has made her one of the most recognized figures in the death penalty debate, has described in extensive interviews and writings what it means to be present with a person in their final hours as their spiritual advisor. Her documented accounts describe the particular quality of attention required, not managing the person's emotional state, not guiding them toward a predetermined spiritual destination, but simply bearing witness. Being, as she has described it, a human anchor in the last hours of human life. Round Pushpin, what happens at 9 p.m.? In most documented state execution protocols, the final 2 hours before execution bring a specific set of procedural changes. Family visits, if they have been occurring, typically conclude. The farewell, which in many documented cases has been anticipated with more dread than any other moment of the final day, happens. The door closes, and the inmate returns to the cell, and the chaplain or spiritual advisor, if present, remains. And what is left is the last hour before the move to the execution chamber. Documented accounts from corrections staff, chaplains, and wardens describe this period as the quietest of the entire day. Paradoxically quiet. The noise of the preceding hours, the phone calls, the legal activity, the family, the procedural processing, has stopped. What remains is 2 people in a small room. One of them will walk out of it. One of them will not. Carol Pickett documented that in his 15 years, he never became accustomed to this moment. That the accumulation of nearly 100 such moments did not dull it, but in some way sharpened it. That each person he sat with in that final hour remained, in his memory, entirely distinct. He can name them all. He still does, in documented interviews conducted years after his retirement. 95 names. Outside the death watch cell, the clock is moving past 10 p.m. The execution team is assembling. The witnesses, some who love the condemned, some who lost someone to the condemned, some who are there because the state requires their presence, are being directed to their assigned rooms. The warden has reviewed the protocol one final time. In the cell, the chaplain is still there. And in approximately 1 hour, a door will open, and the condemned will stand up, and they will walk. The final steps from the cell to the chamber. At 11:47 p.m. on January 17th, 1977, Gary Gilmore walked to his execution. He didn't walk far. The Utah State Prison had constructed a small enclosure, a mattress-lined room inside an abandoned cannery on prison grounds, specifically for this purpose. Gilmore sat in a chair. He was strapped in. A target was pinned over his heart. He was asked if he had any last words. He said, "Let's do it." The firing squad fired. He was the first person executed in the United States after the Supreme Court's 1976 reinstatement of the death penalty following a 4-year moratorium. His case, his insistence on proceeding without appeal, his refusal to allow others to fight for his life on his behalf, made him one of the most documented condemned men in American history before the needle became the dominant method and the walk to the chamber became the defining image of modern execution. But what happened in the minutes before Gilmore sat in that chair, the movement from the place of waiting to the place of death, is the moment that every execution shares, regardless of method, regardless of era, regardless of the specific geography of the institution. The walk. Round pushpin, the mechanics of the final move. In modern American execution protocol, the move from the death watch cell to the execution chamber is a precisely choreographed sequence that has been refined over decades of operational experience across multiple state systems. It does not look like what movies suggest. There is no long corridor walked alone. There is no dramatic march through cheering or jeering crowds. There is no theatrical final journey through a gauntlet of witnesses. What is documented in accounts from wardens, corrections officers, and spiritual advisors who have been present is something far more procedurally contained, and in some ways more psychologically intense because of that containment. In Texas, the distance from the death watch cell to the execution chamber at the Huntsville unit is documented as approximately 45 feet. Some accounts place it slightly longer, others slightly shorter. 45 feet. The walk takes less than 30 seconds. In those 30 seconds, the condemned is accompanied by the execution team, the officers who have been with them throughout the final 24 hours, and in most state protocols, the chaplain walks with them as well. Former Warden Jim Willett documented that the walk was, for him personally, among the most psychologically significant moments of the entire process. Not because of its duration, but because of what it represented as a threshold crossing. Before the walk, the execution remained, in some abstract sense, something that was going to happen. During the walk, it was happening. There was no more waiting. The machinery was in motion, and the person walking beside him had known, with each step, exactly where those steps were leading. Round pushpin, the preparation before the walk. Before the condemned is moved from the death watch cell to the execution chamber, a specific preparation sequence occurs. This is documented across multiple state execution protocols and confirmed in accounts from corrections staff who participated in it. The condemned is offered a change of clothing in some states, a clean set of prison-issued clothing for the execution, distinct from the clothing worn through the day. In other states, they remain in the same clothing they have worn throughout the death watch period. In states using lethal injection, a pre-execution medical assessment confirms that for access is likely to be possible. This assessment is documented in the execution logs that become part of the official record. The condemned is asked one final time if they have any requests or needs. This is not a formality in the way that phrase usually implies. Documented accounts from corrections staff describe this final check-in as a moment that carries genuine weight, an opportunity for the condemned to communicate something, anything, that has not yet been said. Some ask to pass a message to a family member. Some ask about the status of a final appeal. Even at this point, even knowing the answer is almost certainly already determined. Some say nothing, and then the cell door opens. Round pushpin, what happens in the body? The physiological response of the condemned during the walk has been documented through a combination of correction staff observations and, in limited cases, medical monitoring that was part of execution protocols in certain states. What is described consistently across accounts is a range of physical responses that reflect the body's response to extreme psychological stress. Some condemned inmates walk to the execution chamber with a steadiness that correction staff consistently describe as striking, a physical composure that does not match the circumstances. Former Warden Jean Woodford, describing her experiences at San Quentin, documented inmates who walked with what she characterized as deliberate calm. Not the absence of fear, but the active management of it, maintained through concentrated will. Others require physical support. Documented accounts from multiple states include condemned inmates who needed to be steadied by the escort team during the walk. Not because of physical incapacity, but because the body's stress response had produced weakness in the legs, difficulty with coordination, acute trembling. Some vomit. This is documented in correction staff accounts from Texas and other states. It is not in the protocol manuals. It is in the human record. Dr. Robert Johnson, a criminologist at American University who has spent decades researching the execution process and authored Death Work, a study of the modern execution process, documents through his research interviews with execution team members that the physical vulnerability of the condemned during the walk, whatever form it takes, consistently affects the officers who witness it. Even officers who have participated in dozens of executions describe this moment as one that does not become routine. The body of a living human being, moving toward its own death, communicates something that procedural training cannot fully contain. Round pushpin, the execution chamber, what it actually looks like. The execution chamber in most American states using lethal injection is documented as deliberately clinical and spare. The Texas execution chamber at the Huntsville unit, one of the most documented in the country due to the volume of executions carried out there, is described in official records, journalistic accounts, and first-hand testimony as a small room, approximately the size of a large walk-in closet. At its center is a gurney, padded with restraining straps positioned for the arms, legs, and torso. And 4-line runs from the gurney through a small aperture in the wall to an adjacent room where the execution chemicals are prepared and administered. The chamber has 2 windows, one on each side. Through one window, the victim's family and official witnesses observe. Through the other, the condemned's family and personal witnesses observe. The condemned is strapped to the gurney facing the ceiling. They can turn their head to see the witnesses through the glass. Some do not. Round pushpin, the strapping. The process of securing the condemned to the execution gurney is documented in account from corrections staff as one of the most physically intimate and psychologically charged moments of the entire execution process. It requires the execution team to physically handle the condemned, to position their arms, to secure the restraints. In documented accounts, this is done with what corrections officers consistently describe as care, not as an emotional gesture, but as a professional standard. The restraints are checked for security, but not applied with unnecessary force. The positioning is done to ensure the condemned is as physically comfortable as the situation permits. Former Texas execution team member Brian Price, in documented accounts of his service, described this moment as one that required him to be simultaneously procedurally precise and humanly present, to do his job correctly while not treating the person in front of him as an object to be prepared rather than a human being to be acknowledged. He described speaking to the condemned during this process, not formally, not per protocol, simply the ordinary quiet speech of one person acknowledging another. He was not required to do this. He did it because not doing it felt, in his words, like something he could not do to another person. Round pushpin, the 4-line. The insertion of the 4-line, through which the lethal drugs will be administered, is among the most procedurally sensitive and legally contested elements of the modern execution process. It is performed by execution team members who, under the ethical guidelines of virtually every major medical and nursing professional organization, cannot be licensed medical professionals. The American Medical Association, the American Nurses Association, and equivalent bodies have issued formal position statements prohibiting their members from participating in executions, including the insertion of 4 lines. This means the people inserting 4 lines for executions are trained specifically for this purpose through state corrections training programs, not through clinical medical education. The practical consequences of this are documented in the execution record. Difficulties finding veins have been documented in multiple high-profile cases. Clayton Lockett's 2014 execution in Oklahoma, which became the subject of extensive investigative reporting, legislative inquiry, and legal challenge, involve a ruptured vein that resulted in an execution that lasted 43 minutes and was described by the director of the Oklahoma Department of Corrections as a medical disaster. Lockett was documented as moving, groaning, and speaking after the execution drugs had been administered. The execution chamber blinds were lowered to prevent witnesses from observing what was occurring. He died approximately 43 minutes after the execution began, not from the intended administration of the lethal drugs, but from a heart attack. The documented aftermath of that execution included corrections staff who required psychological support, officials who described it in testimony as among the most disturbing events of their professional careers, and a national legal and policy debate about the constitutionality of lethal injection methods that continues to this day. Round pushpin the witnesses. On the other side of the glass, the witnesses have been assembled. The witness process, who is permitted to observe an execution, how they are prepared, and what support is available to them, is documented across state protocols and an account from people who have served as witnesses. In most states, witness categories include official state witnesses required by law, media witnesses selected through a pool system, the condemned's designated personal witnesses, typically family members or close associates, and the victim's family witnesses. These groups are typically separated, different rooms, different viewing windows, or different sections of the same witness area to prevent direct interaction during the execution. The preparation of witnesses is handled by designated corrections staff. In documented accounts, this preparation includes a briefing on what will occur, what sounds may be heard, and what the witnesses should expect to observe. Some witnesses have documented being told to remain silent. Others have documented being told they may leave if they need to. All are told, in one form or another, that what they are about to see cannot be undone and cannot be unseen. Sister Helen Prejean documented her experience as a spiritual witness to condemned inmates in Louisiana, standing in the chamber with them as their designated spiritual advisor, making eye contact with them in the final moments, providing the last human connection they would have before death. She documented this as the most extreme form of human witness, being the last face a person sees. She described the responsibility of that as something that has stayed with her undiminished across every case. Round pushpin the final statement. In most state execution protocols, the condemned is offered the opportunity to make a final statement after being secured to the gurney. The final statement, delivered verbally in most states, with a written copy recorded by the warden or a designated official, becomes part of the official execution record, and in most states is made available to the public. The documented archive of final statements from American executions constitutes one of the more extraordinary collections of human expression available anywhere. Some are brief. Joseph Cannon, executed in Texas in 1998, reportedly began his statement, stumbled, asked to start over, and was permitted to do so. The exchange, a condemned man asking for a second chance as last words, and the warden allowing it, appears in the documented execution log as a procedural note without elaboration. Some final statements are expressions of love, directed at family members visible through the glass, or at family members not present, named specifically and addressed directly as if the person could hear. Some are expressions of religious faith, prayers spoken aloud, scripture quoted, expressions of belief in what comes after. Some are apologies. The documented final statements of inmates who expressed remorse for their crimes constitute a body of human documentation that forensic psychologists, theologians, and legal scholars have studied for what they reveal about culpability, conscience, and the capacity for moral reckoning under conditions of absolute finality. Some final statements maintain innocence. Cameron Todd Willingham, executed in Texas in 2004 for the deaths of his 3 daughters in a house fire, a case that subsequent forensic fire investigation analysis called deeply flawed, maintained his innocence in his final statement. Post-execution forensic reviews of the evidence in his case have been cited by capital punishment critics as among the most significant documented cases of potential wrongful execution in American history. His final statement is in the record. The questions about his case are also in the record. Both remain. Round pushpin the moment before. In the seconds between the final statement and the beginning of the execution protocol, there is a moment that corrections officers, wardens, and spiritual advisors have described across dozens of documented accounts with striking consistency. A stillness, not silence. The sounds of the room continue. The mechanical sounds of the equipment, the breathing of the people present. But something in the quality of the moment changes. Former Warden Jim Willett described this moment as the one that stayed with him most vividly across the 89 executions he oversaw. Not the death itself, the moment before. When everything that could be said had been said. When everything that could be done had been done. When the person strapped to the gurney, whatever they had done, whatever had been done to them, whatever the accumulated weight of their life and trial and incarceration amounted to, was entirely, irreducibly, unmistakably alive. And then the signal was given. And then it began. The drugs move through the 4-line in a sequence that takes approximately 7 minutes under standard protocol. The first drug, a sedative, typically midazolam or sodium thiopental in historical protocols, is administered. The second drug, a paralytic agent, follows. The third drug, potassium chloride, stops the heart. The warden watches. The witnesses watch. The chaplain watches. And the clock, the institutional clock on the wall of the execution chamber, documented in every execution log, records the time. The time of death is announced. The witnesses are escorted out. The chamber is cleared. And somewhere in the institution, in the warden's office, in the chaplain's notes, in the psychological processing of every person who is in that room, something begins that the execution protocol does not cover. What comes after? The aftermath, what happens after the clock stops, to the body, the family, the officers, and the system. At 6:17 p.m. on February 3rd, 1998, Carol Pickett walked out of the Huntsville Unit Execution Chamber. Carla Faye Tucker had been pronounced dead 4 minutes earlier. He got his car. He drove to a parking lot near the prison, and he sat there for a long time. He did not go home immediately. He did not call anyone. He did not debrief with colleagues or process with a counselor or fulfill any of the institutional obligations that come after an execution is concluded. He just sat. This detail, a chaplain sitting alone in a parking lot after his 90-second execution, does not appear in any official protocol document. It is not part of the procedure. It is not accounted for in the execution timeline or the official record, but it is documented, in his own words, in interviews conducted years later. And it is, in many ways, the most honest entry point into what the aftermath of an execution actually looks like. Not for the institution, not for the legal record, not for the official narrative, but for the human beings who were in that room. Round pushpin, the official aftermath, what the protocol covers. The minutes and hours immediately following an execution are governed, like everything else in the process, by documented protocol. The pronouncement of death is made by a physician, one of the few points in the execution process where a licensed medical professional is formally present, called in specifically for this purpose after the execution is complete rather than during it. The time of death is recorded in the execution log. This document, a formal institutional record, becomes part of the permanent file associated with the case. It joins the trial transcripts, the appeals documentation, the clemency records, and the death warrant itself as the official paper trail of a human life as processed by the criminal justice system. The witnesses are escorted from their respective viewing areas by designated corrections staff. In documented accounts, this process is handled with deliberate care. Witnesses are not simply released into a common space. Victim family witnesses and the condemned's family witnesses are kept separated through the exit process, routed through different corridors or at different times to prevent interaction in the immediate aftermath. The execution chamber is secured. The body of the condemned remains on the gurney until it is released to the designated receiving party, which may be a funeral home contracted by the state, a funeral home designated by the condemned's family, or in some documented cases where no family arrangement has been made, a state-contracted mortuary service. In Texas, unclaimed bodies of executed inmates have historically been buried at the Joe Bird Cemetery, known colloquially as Peckerwood Hill, adjacent to the Huntsville unit. The cemetery contains the graves of hundreds of inmates, including executed prisoners whose families did not claim their remains. The grave markers are simple: a metal cross or marker, a name, a date. The documentation of this cemetery, its existence, its population, the names recorded there, is one of the more quietly devastating artifacts of the American execution system. Round pushpin, the condemned's family, the hour after. For the family members of the condemned who were present as witnesses, the hour immediately following the execution is documented as one of the most psychologically disorienting of the entire experience. They have watched a person they love die, not unexpectedly, not suddenly, with complete foreknowledge of when and how it would happen. In documented accounts from family members of executed inmates, compiled through academic research, journalism, and the work of organizations that provide support to families of people on death row, the immediate aftermath is described with a consistency that crosses demographic lines, geographic regions, and specific case circumstances. The body does not look like sleep. This detail appears in multiple documented accounts. Family members who expected the process to resemble the medical deaths they had witnessed. The gradual, peaceful cessation documented in hospice settings, described being unprepared for what they actually observed. The physical reality of execution by lethal injection, even when the process functions as intended, is not identical to natural death. The documented physiological responses that can occur during the administration of the paralytic and cardiac arrest drugs have been the subject of extensive legal challenge, with medical experts arguing in court that the paralytic agent may mask pain responses that the sedative does not fully suppress. This debate, whether lethal injection constitutes cruel and unusual punishment under the Eighth Amendment, has not been resolved by the Supreme Court. It remains active in litigation. But for the family members standing at the observation window, the legal debate is not what they are processing. They are processing the fact that the person they came to witness, whatever their relationship with that person, whatever the complexity of loving someone who has been condemned, is gone. And they're standing in a room in a prison. And they have to get home somehow. Round pushpin, the victim's family, the complicated truth. The documented experiences of victim families following executions challenge one of the most persistent assumptions in the public narrative around capital punishment. The assumption is that execution brings closure. The documented record does not consistently support this. Researchers studying the psychological outcomes of victim families who witnessed executions, including work published through the Marquette Law Review and research conducted by murder victim family advocacy organizations, have found that the relationship between witnessing an execution and experiencing relief, closure, or reduced grief is far more complex and variable than public discourse typically acknowledges. Some victim family members document experiencing genuine relief, a sense that the legal process has reached its conclusion and that they can begin to move forward in a way that was not possible while the case remained open. Others document experiencing renewed grief, the execution triggering a re-experience of the original loss rather than resolution of it. Some document experiencing unexpected responses entirely, including distress at witnessing the execution itself, regardless of their position on the justness of the sentence. Bud Welch, whose daughter Julie was killed in the 1995 Oklahoma City bombing, initially supported the death penalty for Timothy McVeigh. He later became one of the most prominent opponents of McVeigh's execution, meeting with McVeigh's father and speaking publicly about his belief that the execution would not heal his grief and would create another family's loss. McVeigh was executed anyway. Welch's documented accounts of the period after the execution describe not resolution, but a complex reckoning with what justice means when the legal process has completed its course and the grief remains unchanged. His testimony is not an argument against execution. It is a documented human account of what closure actually looks like, or doesn't look like, in the aftermath of state-sanctioned death. Round pushpin, the execution team, the cost nobody counts. The psychological impact on corrections officers who participate in executions is among the least discussed and most consistently documented dimensions of the execution aftermath. is not in the official protocol. It is in the human record. Dr. Robert Johnson's research, based on extensive interviews with execution team members across multiple states, documents a pattern of psychological consequences that correction systems have historically been poorly equipped to address. Sleep disturbances, intrusive memories, difficulty separating professional and personal identity, a phenomenon that Johnson and other researchers describe as a form of moral injury, not post-traumatic stress in the clinical sense, though that is also documented, but something more specific, the psychological cost of participating in an act that, regardless of its legal sanction, involves the deliberate ending of a human life. Former execution team members from Texas, documented in journalistic investigations and academic research, describe the accumulation of executions as having a cumulative psychological weight that does not diminish with repetition. Some describe the first execution as the one that affected them most acutely, the shock of encountering the reality of what the training had prepared them for. Others describe the 5th or the 20th or the 50th as the moment something shifted, when the procedural competence they had developed began to feel like something they could no longer separate from themselves. Brian Price, the former Texas execution team member whose documented accounts appear in multiple publications on the subject, left corrections work and subsequently became a vocal advocate for providing mandatory psychological support to execution team members, support that, in most documented state systems, has historically been voluntary, stigmatized, and underutilized. A 2015 study published in academic literature on correctional officer mental health found that officers who had participated in executions reported significantly higher rates of psychological distress than officers with equivalent tenure who had not. The study's authors noted that this finding was not surprising, but that the corrections system's formal response to it had been inadequate. Warden Jim Willett, in documented interviews following his retirement, described the weight of his 89 executions as something he carries daily, not with dramatic suffering, not in a way that has incapacitated him, but as a permanent presence. He still thinks about them, all of them. Round pushpin the exoneration cases, the shadow over the system. Any honest accounting of the aftermath of capital punishment must include the documented cases of wrongful execution or near wrongful execution that constitute the most severe indictment of the system's fallibility. Since 1973, more than 190 people have been exonerated from death row in the United States, according to the Death Penalty Information Center's documented records. These are people who were sentenced to death, spent years or decades on death row, and were subsequently proven innocent through DNA evidence, recanted testimony, prosecutorial misconduct findings, or other post-conviction review. 190 people who were not exonerated. The question of how many executed individuals were innocent cannot be answered with certainty. But the documented record includes several cases where post-execution evidence reviews have raised serious questions. Cameron Todd Willingham, executed in Texas in 2004, is among the most extensively documented. The fire investigation methodology used to convict him of arson murder, the deaths of his 3 young daughters, has been reviewed and critiqued by multiple independent forensic fire experts, whose findings suggest the forensic basis for the arson conclusion was scientifically unsound. Willingham was executed. The Texas Forensic Science Commission subsequently investigated the case. Its review process was politically contentious and ultimately inconclusive regarding the legal question of innocence. But the documented scientific critique of the original forensic evidence has never been refuted. His final statement, maintaining innocence, is in the record. The forensic questions are in the record. He's not alive to know that the questions are still being asked. Carlos de Luna, executed in Texas in 1989, is the subject of a Columbia Human Rights Law Review investigation published in 2012 that documented evidence suggesting another man, Carlos Hernandez, committed the murder for which de Luna was executed. The investigation, spanning hundreds of pages of documented research, represents one of the most thorough post-execution innocence investigations in American legal history. De Luna was 27 years old when he was executed. He maintained his innocence. The investigation was published 23 years after his death. Round pushpin the warden's office, the night after. The paperwork generated by an execution continues for hours after the death is pronounced. The execution log is completed and signed. The witness documentation is finalized. The media statement, typically brief and procedural, is prepared if not already drafted. The notification protocols for relevant parties are completed. In the warden's office, in documented account from wardens who have spoken about their experiences, the night after an execution is described with a consistency similar to the accounts from chaplains and execution team members. They do not sleep easily. Gene Woodford, whose 4 executions at San Quentin included Robert Lee Massey in 2001, a man who had spent nearly 30 years on death row and who, like many long-term death row inmates, was a substantially different person at the time of his execution than the person who committed the crime, documented her experience as warden in interviews and advocacy work following her departure from corrections. She described the night after as a reckoning. Not with guilt. She had carried out her lawful duties with professionalism, but with the weight of what those duties had entailed, with the irrevocability of what had occurred, with the face of the person she had watched die. She became, after leaving corrections, one of the more prominent corrections professionals to publicly oppose capital punishment, joining a documented cohort of former wardens, execution team members, and corrections administrators whose proximity to the execution process produced not confirmation of its justness, but serious doubt about it. Their testimony, documented across journalism, advocacy organizations, and academic research, represents a category of evidence about capital punishment that is distinct from legal argument or statistical analysis. It is the testimony of the people who were in the room. Round pushpin the morning after, the world that continues. By the morning after an execution, the institution has returned to its operational rhythm. This is perhaps the most disorienting fact documented in accounts from every category of person involved in the execution process. The prison wakes up. Meals are served. Counts are conducted. The machinery of institutional life resumes without pause. The death watch cell, vacant now, is cleaned and reset, because there is, in most active execution states, another case moving through the appeals process. Another condemned person whose date has not yet been set, or has been set and is being challenged, or will be set when the current round of litigation concludes. The system does not pause to reflect. It processes, and outside the walls, the world that barely noticed continues. The execution of a person who has been on death row for 15 or 20 or 30 years generates, in most cases, modest media coverage, a brief news item, a statement from the Attorney General, a statement from the condemned's legal team, and then the news cycle moves, and the people who are in that room are left with what they carry. Round pushpin the larger question the system cannot answer. The documented aftermath of capital punishment, across the cases, across the decades, across the testimony of every category of person who has been proximate to it, raises a question that no protocol manual addresses and no execution log records. Whether any of it accomplished what it was designed to accomplish. Deterrence research, the documented academic literature on whether the death penalty reduces violent crime, has not produced consistent evidence of a deterrent effect. Studies finding deterrent effects have been challenged. Studies finding no effect have been challenged. The National Research Council, in a 2012 review of the existing research, concluded that existing studies were fundamentally flawed and should not be used to inform judgments about the effect of the death penalty on homicide rates. The documented exoneration rate, 190 people freed from death row since 1973, raises questions about systemic accuracy that the legal system has addressed procedurally but not resolved philosophically. The documented psychological cost to corrections officers, wardens, and chaplains, people who entered public service to manage institutions, not to participate in executions, raises questions about what the state asks of the people it employs. The documented variability in victim-family outcomes, the cases where execution did not produce closure, where it produced renewed grief, where it produced unexpected moral complexity, challenges the narrative that drives much of the public support for capital punishment. These questions are in the record. They do not have execution protocol answers. They have only human ones. Round pushpin Carol Pickett, the parking lot. In that parking lot outside the Huntsville unit, on the night of February 3rd, 1998, Carol Pickett sat with 92 executions behind him. He had walked into cells with men who were terrified, men who were at peace, men who were angry, men who were broken, men who were, in the assessment of every person who had known them in their final years, not the same people who had committed the crimes for which they were being executed. He had played cards. He had prayed. He had listened to things that could not be unsaid. He had walked 45 feet with 92 people and stood in a room where all of them died. And he sat in his car, not because the institution required it, not because the protocol covered it, but because a human being who has witnessed what he had witnessed needs, at some point, to simply stop moving and allow the weight of it to be what it is. He retired from his chaplaincy shortly after. In documented interviews conducted years later, he described his opposition to capital punishment, a position he had not held when he began his service, as having been formed not through argument or ideology, but through proximity, through the 45 feet, through the 92 names he still carries. What happens in the last 24 hours on death row is, in the end, documented. It is in the records, the testimonies, the execution logs, the academic research, the memoirs of wardens and chaplains and corrections officers who were there. What it means, what it says about justice, about the state, about human beings, and what we are capable of doing to each other in the name of what we believe is right, is not in any protocol. It is in the parking lot. It is in the 92 names. It is in every question that outlasts the answer the execution was meant to provide. You just spend time inside a process that most people will never see. Not the version that appears in films. Not the version that appears in political speeches. The documented version. The human version. The version that lives in execution logs and chaplain memoirs and the testimony of corrections officers who spent years in those corridors and came out changed. Here is what the record actually shows. The last 24 hours on death row is not a single dramatic moment. It is a sequence of procedures, human connections, legal maneuvers, psychological ruptures, and quiet conversations that collectively constitute the most extreme experience available in the American institutional system. It involves people doing their jobs, wardens, officers, chaplains, medical staff, in circumstances that their training can approximate but cannot fully prepare them for. It involves families on both sides of a divide, the family of the condemned and the family of the victim, navigating grief and loss and the specific, documented complexity of what state-sanctioned death does and does not resolve. It involves a condemned person, a human being, whatever they did, spending the last hours of their life in a 45-square-foot room, making phone calls, signing paperwork, being asked what they want to eat, and walking 45 feet. And it involves a system that has, by documented count, sentenced more than 190 innocent people to die, and caught that error before it was completed, while raising unresolved questions about the cases where the error was not caught in time. The United States remains one of the only developed democracies that still carries out executions. The documented global trend is toward abolition. As of 2024, more than 55 countries retain the death penalty in law or practice. More than 140 have abolished it in law or in practice. The debate in America continues. The executions continue. And in the Huntsville unit, the death watch cell is clean and waiting. Because the system does not pause. It processes. If this video made you think, not necessarily in one direction, but think, then it did what it was supposed to do. The story of what happens in the last 24 hours on death row is not a story about monsters and justice. It is a story about human beings and institutions and the irreversible weight of finality. That weight belongs to all of us, not just to the people in that room. If you want to go deeper, the story of what happens inside death row over years of waiting, what the psychological research says about what long-term death row confinement does to human beings, and the documented cases where the system got it catastrophically wrong. That story is coming. subscribe, and turn on notifications, because the next one is going to go places this one didn't.